Be more comfortable than inside than outside. It's more comfortable inside. But it is very hot. But certainly we'll go outside and that will be difficult.
For admission item 30, cost of 107 of 1025.
Under speed post and ordinary process we filed by 6th of January 26 spring. Let the records be called from the concerned court. Since the counsel for the applicant is absent, office is ready to forward a copy of this document to the counsel. It's a soft copy. Post on 26th of March.
Item 31, cost of 108 of 1025.
Sentence fixed. Whereby the judgment court has dismissed the suit, which was partitioned of the suit.
Admit. Issue notice to the respondents for which duties is under speed post and ordinary process be filed by 6th of January 2026.
At least 3 weeks.
State and read the calculation. Or same order, 26th of March. 20 order है comply है. DC को मत छोड़ दीजिएगा.
For hearing on order 41/11, item 32, second appeal 212 of 2020.
In this case, the appellant number 5 has died.
It's a number 212/2020. The counsel for the appellant has submitted that. Appellant number 5 has.
5 has.
When?
Well, they have told me the year, sometimes 24, but I have asked them to give the death certificate so that this appropriate application would be filed. Sometimes it will be 24 days.
Sometimes in 24.
In the year 24 itself, but I am asking them to give me their death certificate so that we can file the subsequent petition.
As per instructions, the appellant number 5 has expired sometimes in the year
2024.
If that be so, the appeal in connection with appellant number 5 has abated. However, the legal counsel for the appellant seeks adjournment and submits that the entire picture will be cleared upon receipt of the death certificate. तब से अबेट तो हो ही गया है. Date कब को ये बताओ।
पिटीशन फाइल करना पड़ेगा, we have to file a petition, right?
आप choose करिए ना, choose your date.
In the third week of January, we will be filing.
Post on 19th of January.
Item 33, second bill 102 of 2022.
Madam, in the morning, you were the amicus in the case. आप कुछ तैयारी किए?
उसको पढ़े थे properly and I just assisted and Akash Deep sir
You are not supposed to assist anybody when you are in amicus in the case. कल आपको सुनिए. Amicus is not supposed to assist anybody. Everybody will assist.
paper short possible.
Essay number 102 of 2022. Also for the event, you can pass over. Post on 5th of January.
Item 34, second bill 202 of 2023.
Any supplement?
Concurrent finding of the court against the appellants.
You are the plaintiff or the defendant?
Appellant,
You are the plaintiff or the defendant?
plaintiff,
You are the plaintiff. Partition suit has been dismissed.
that has been dismissed, my lord. I will raise only 2 points for your lordship consideration. My lord, the evidence was laid before the trial court that Umar Rai and Gauri Rai were full brothers. And in support of the plea, sufficient evidence was laid. And for reference, all the records of right entry made during the cadastral survey was entered in the name of Gauri Rai and Umar Rai, showing them as brothers.
Son of?
Son of Lakshman Rai.
Lakshman Rai. In the cadastral survey.
Lakshman Rai.
In the cadastral survey.
In the cadastral service. Yeah. तो उनका रेगुलर का केस है वो जो इसमें Exhibit 1, certified copy of Khatiyan, slip of Jamabandi Khata number 29 of Moja Raniganj, the name
Which is
of
that document? You said that in cadastral survey, Umar Rai and Gauri Rai were shown as sons of Lakshman Rai. Where is that discussion?
Exhibit 1, my lord,
Exhibit 1 में आप judgment से दिखाइए ना.
certified copy of Khatiyan, And not only this entry, my lord, other entries in support of my contention. Exhibit 1 by 1, certified copy of Khatian slip number JB number 19 of Mauja Raniganj. Exhibit 1 by 1 to Khatian slip of JB number 34 of Mauja Raniganj, which clearly shows that Harihar Rai, Panchanan Rai and Hakim Rai were all sons of Gauri Rai.
No, गौरी राय का बच्चों की बात नहीं है, आप तो
And
उमा
Bhagi
राय-
Rai and Bhagi Rai were sons of Umar Rai.
No, I just want to know which Khatian has shown that Uma Rai and Gauri Rai are sons of Lakshman. Which is that document which shows that Uma Rai and Gauri Rai are sons of Lakshman?
All these documents which I have
Which
mentioned.
document दिखाइए ना, कौन सा document आपके पास है ना? देख के बोल रहे होंगे आप. Which document is that?
Yes.
Which document is that? बताइए.
सब हिस्सेदार का नाम लिखा हुआ है.
हिस्सेदार का नाम नहीं पूछ रहे सर, आप हमको पेंसिल से मार्क करके बताइए कहाँ है उमा राव एंड गौरी राव आर सन्स ऑफ लक्ष्मण राय. हमको पेंसिल. Which document and which is that exhibit?
वो तो उसमें समझो पेरेंटेज तो दिया हुआ नहीं रहता है इसमें.
आप बोल रहे हैं कि खतियान में लिखा है, तो आप तो पूछ रहे हैं कहाँ लिखा है.
Pencil.
केस ऑफ रेस्पेक्टिव पार्टीज पढ़िए. एपलेट कोर्ट का जजमेंट से पढ़िए केस ऑफ रेस्पेक्टिव पार्टीज. पैरा नंबर 3 पढ़िए. पैरा 3.
In nutshell, the appellant gravely places follows the appellant and respondent governed by the contract civil law. The civil property described in the plaint is going to be recorded in the name of Hari Rai, Panchanan Rai, Hakim Rai, son of Gauri Rai, and Bari Rai and Bhagi Rai, son of Umar Rai. In the Parcha of last service settlement.
पढ़िए पढ़िए.
The
केस है
aforesaid
ना.
aforesaid property acquired by the recorded tenants out of joint family funds and efforts. The common ancestor of both parties was Lakshman Rai. He died leaving behind two sons, Gauri Rai and Uma Rai. Both Gauri Rai and Uma Rai died prior to cancer settlement. Gauri Rai died leaving behind three sons, Hari Rai, Kamchand Rai and Hakim Rai, and Uma Rai died leaving behind two sons, namely Dwari Rai and Bhavi Rai. The sons of Gauri Rai and Uma Rai jointly inherited the interest of their respective fathers in the ancestral property, and they remained joint, so possession was recorded in joint purchase of the last cancer settlement. Therefore, the ancestral lands described in the Schedule A of the plan were recorded jointly in the name of Hari Rai, Kanchand Rai, Hakim Rai, sons of Gauri Rai, and Dwari Rai, Bhari Rai, sons of Uma Rai, in the purchase of cancer settlement. The recorded tenant Hari Rai died in or about 1957 in the state of jointness, leaving behind only a daughter, namely Rukmini Devi. The wife of Hari Rai had already been deceased to him. After the death of Hari Rai, his interest devolved upon Rukmini Devi. Further, the case of the plaintiff is that although Rukmini Devi was successor of Hari Rai, but she had not been in possession of the interest of Hari Rai in the lands. So the defendant's respondents are alleged as defendant first party have also not come in the possession. Further, the case of the plaintiff appellant is that other respondents, defendants are the heirs of the recorded tenants Pancham Rai, Hakim Rai and Bhari Rai and Bari Rai. Further, the case of plaintiff appellant is that after the death of recorded tenants, namely Hari Rai, Panchanand Rai, Hakim Rai and Bari Rai, the descendants of Panchanand Rai and Hakim Rai separated in mess, residence and cultivation from alive recorded tenants Bhari Rai and sons of Bari Rai. Bhari Rai and the sons of his brother Dwari Rai remained joint in all purposes, and Bhari Rai was remained Karta, manager of the aforesaid joint family. After the death of Bhari Rai, his son Jugal Rai and sons of Dwari Rai remained joint in all respect for a long time, and after the death of the said Jugal Rai, the sons of Jugal Rai and the descendants of Dwari Rai separated in mess, residence and cultivation. The defendants have relied and referred petition suit number 4 of 1964 and its judgment and decree, final decree also suppressing the fact that the suit was collusive one against the Parcha
सर,
entry.
आपका एक पहले आपका एक टाइटल सूट हुआ है, टाइटल सूट नंबर 4 of 1960. You said that was
कॉलिसिव
fraudulent.
था, जो कॉलिसिव था, इसमें वो लोग कंप्रोमाइज के बेसिस पर इस पर सक्सीड किए.
आप पार्टी थे ना उसमें?
Against that, the matter was
Were you also party in that suit?
revenue officials.
Were you also party in that suit? You were a party. It's a family partition.
Not all the parties were.
Who was not party?
My lord, the appellants before your lordship, my lord.
आपके predecessor in interest तो party रहे होंगे ना?
कुछ हिस्सेदार थे और कुछ नहीं थे, जो हमारे खिलाफ थे उनको मिला के उन्होंने एक दरखास्त दे दिया और उसमें कॉलिसिवली उन्होंने पार्टीशन की कॉम्प्रोमाइज के बेसिस पर डिग्री हासिल कर लिया. तो उसको हमको चैलेंज करने के लिए रेवेन्यू कोर्ट में भी कहा गया. जो हमने जो रेज किया एक पॉइंट को रेवेन्यू कोर्ट में, तो रेवेन्यू कोर्ट ने कहा कि आप फ्रेश टाइटल सूट फाइल कीजिए, तब हम आए हुजूर कोर्ट में. मेरा कंटेंशन है हुजूर की unless this matter is decided that Gauri Rai and Uma Rai were brothers and not father and son, then my lord, how the order could be sustained, my lord, in the by both the courts below, my lord, and that is against, my lord, the entry found to be made in the name of Hari Rai, Gauri Rai and Uma Rai.
Gauri Rai and Uma Rai, which is that document which shows that they are sons of Lakshman Rai. आपको बार बार पूछ रहे हैं तो आप बोल रहे बाप का नाम नहीं लिखा हुआ है रिकॉर्ड ऑफ राइट.
उसमें वो जो स्पेसिफिक
नहीं है ना.
लेकिन जो अमीन का रिपोर्ट तब है एग्जीबिट.
अमीन का रिपोर्ट डिसाइड करेगा कि कौन किसी का पिताजी हैं. ठीक है. सेकंड अपील नंबर 204/2023 for the learned counsel giving on behalf of the applicants. This appeal has been filed by the plaintiffs who has lost in both the courts. filed against judgment dated 6/6/2023, in bracket DT signed on 19/6/2023, bracket close, passed by the District Judge 1 Madhur in civil appeal number 38 of 2019, whereby the District Judge 1 has appealed the judgment dated 11/6/2019, in bracket DT signed on 26/2019, passed by learned civil judge in bracket senior division bracket close 1, therefore indicted in bracket party bracket close number 70 of 2005.
एग्जिबिट वन जरा सा हुजूर देखा जाए, उसी से क्लियर हो जाएगा हुजूर कि देवर ब्रदर्स।
कहाँ है एग्जिबिट?
इसमें फर्स्ट पेज जो हुजूर है,
हाँ, तो मार्क कर
इसमें उसमें हुजूर लिखा हुआ है, ये नाम होगा सच एंड सच।
सच एंड सच मत पढ़िए, हमको नहीं समझ आता है सच एंड सच।
यहीं पर देखा जाए हुजूर, पेशराम उमा राय अलग हैं और पेशराम गौरी राय अलग है। गौरी राय के बच्चे अलग हैं, उमा राय के बच्चे अलग हैं। हुजूर देखा जाए थोड़ा सा देख लीजिए।
The learned counsel for the appellant has submitted that the reports have wrongly interpreted Exhibit 1 in as much as the children of Uma Rai and Gauri Rai have been duly named in the said exhibit. This itself, according to him, this itself goes to show that Uma Rai and Gauri Rai were brothers. The learned counsel submits that both of them were sons of Lakshman Rai. He submits that on account of this aspect of the matter, both the judgments are perverse and a substantial question of law will change. यही आपका केस? After hearing the learned counsel for the appellant, this court finds that the suit was filed for a preliminary decree specifying the plaintiff's share with respect to the suit properties. The specific case of the plaintiffs was that the properties in Schedule A was recorded in the name of Adi Rai, Pancham Rai, Hakim Rai, sons of Gauri Roy, and Dwari Roy and Bhardi Roy, sons of Uma Roy, in the gangsters settlement, and the property described in Schedule B, C, D, E, and F were acquired jointly by the aforesaid recorded tenants out of joint family fund. It was a further case that Lakshman Roy was the common ancestor of the parties, and he died leaving behind his two sons, namely Gauri Roy and Uma Roy, who had jointly inherited the property. It was the further case that the recorded tenant Hari Roy died in 1957 in a state of drunkenness, leaving behind his only daughter, Rukmani Devi, and his wife had predeceased him. After death of Hari Roy, his interest devolved upon his only daughter, Rukmani Devi, and after death of Rukmani Devi, the same was succeeded and devolved upon the dependent first party as her descendants. Though Rukmani Roy was the legal heir of Hari Roy, but he was not in possession of the interest of Hari Roy, and therefore the dependent first party were also not in possession of the interest of Hari Roy. The dependent second party are the descendants of recorded tenant Pancham Roy and Hakim Roy, and dependent third party are the descendants of recorded tenant Hari Roy. And further, dependent fourth party and the plaintiffs are the descendants of recorded tenant Gauri Roy. It was their case that after the death of the recorded tenants, namely Hari Roy, Pancham Roy, Hakim Roy, and Gauri Roy, the descendants of Pancham Roy and Hakim Roy separated in mess, residence, and cultivation from that of the recorded tenant Hari Roy and sons of Gauri Roy. Further, Hari Roy and sons and his brother Gauri Roy remained joint in mess, house, and cultivation. And Bharti Roy was the karta of the joint family of himself and sons of Gauri Roy. After death of Bharti Roy, his son Dugal Roy and sons of Gauri Roy remained joint in all respect for a long time. And after death of Dugal Roy, the sons of Dugal Roy and the descendants of Gauri Roy separated in mess, residence, and cultivation. It was the further case that in course of trial, it was learned that dependent first party and second party had relied and referred in title partition suit number 4 of 1964 and its judgment and decree and also final decree, and it was asserted that the suit was collusive and against the Parcha entry and without joining necessary parties. And in the state partition suit, it was wrongly shown that Umar Rai was son of Gauri Rai in the genealogical table of the plate. It was also asserted that even the Amin Commissioner report in title suit number 4 of 64 was collusive. And without notice to the contesting defendants of the suit.
5 of the.
Yes. It was also asserted that the plaintiff and the defendant in collusion of the said suit in collusion played fraud against the contesting defendant and filed a compromise petition amongst themselves, and the suit was ultimately disposed of. It was asserted that the decree passed in the Tati suit number 4 of 1964 was not binding upon the present plaintiffs. It was then asserted that there has never been partition of the joint properties and was being cultivated separately by way of convenience, and in absence of a regular partition suit, and in absence of regular partition, the plaintiffs called upon the defendants in March 1998 for an amicable partition, to which the defendants did not agree. It was also asserted that the scheduled property has been found in possession of the parties as per the legitimate share, which completely falsified the entire foul game of Title Suit number 4 of 1964 and its subsequent elusive order. And the cause of action for the present suit was sometimes in the month of March 1988. The defendant, first party and second party, number 1, 2, 4, 5, 6, 9, 10, 11, 12, 13, 14, 16, 19, 20, 24, 28 and 29. 5 directly stated to allege that the suit was collusive by suppressing and was filed by suppressing earlier suit, which was title partition suit number 4 of 1964. The said suit was filed by late Rukmani Devi, the only daughter and heir of Hari Rai, who died on 13/4/1957. And defendant first party was allotted, the 1/4 share was allotted to her after partition by meets and bounds, who was being represented by the defendant first party. It was also asserted that the plaintiff's grandfather, Saukhi Rai, and his brothers and uncles, Hadi Rai, were represented fully in the branch of Umar Rai. The eldest son of Gauri Rai and brother of recorded tenant Hari Rai and other contested persons in the suit. It was hotly contested. It was also asserted that the plaintiff's claim of 1/4 share was decreased in the said suit, and the contesting defendants, including plaintiff's predecessor in interest, were in appeal. It was decided by the learned second ADJ by judgment dated 30/3/1974 in title appeal number 35 of 1966/74 of 1973, which was dismissed on merits. The second appeal was also dismissed by the High Court. Later on, the suit was transferred to the Court of Assistant Settlement Officer later for hearing during final decree, wherein it was numbered as title within bracket partition bracket close suit number 4 of 1984, which after thorough hearing and partition final decree was passed on 24/4/1987, where all the 4 branches of Umarai, Harirai, Pancham-Rai and Hakim Rai were fully represented and allotted their respective shares 1/4 each. It was also asserted that Umarai was the. It was also asserted that had Umarai been brother of Gauri Rai, then in title partition suit number 4 of 1964, the branch of Umarai would have been entitled to half share and not 1/4 share. It was denied that it was admitted in the previous partition suit relationship that Umarai was son of Gauri Rai and brother of Hari Rai, and his recorded 2 brothers, and so the genealogical table was admitted, and there was never any plea that Umarai was brother and not son of Gauri Rai. The defendant number 32, 33, 34 and 35 also filed a written statement who supported the case of the plaintiff by stating that the genealogy projected by the plaintiff was true. The defendant number 37, 41, 42, 43, 44, 45 and 46 also filed their written statement. And supported the case of the plaintiffs. And asserted that the decree in title partition suit number 2 of 1964 was produced and was obtained by committee. The following issues were framed by the learned tribunal. The learned tribunal considered the oral and the documentary evidences. And took up issue number 3, 4 and 6 together. And ultimately, the issue was decided in favor of the defendants. The court recorded that the genealogical table given by Rukmani Devi is to be admitted by all the contesting defendants, and the defense was only regarding previous partition. The court also recorded that the relief sought for in the plaint did not whisper any relief for undoing the preliminary and final decree, including the delivery of possession of the allotted share passed and confirmed by the competent civil court in the earlier title partition suit number 4 of 1964. It was also recorded that the oral evidence given by the plaintiff himself would establish that the plaintiff was born after the passing of the final decree in title partition suit number 4 of 1964. As in cross-examination, it has come that his year of birth was 1978. The court also recorded that in paragraph 16 of his deposition, the plaintiff admitted the fact that Jamuna Prasad Ray was his Baba with Dada, and as per the genealogical table, Jamuna Ray was described as the grandson of Hakim Ray. And the plaintiff also admitted the fact that Sauki Ray was his own grandfather, and in this way, Sauki Ray and Jamuna Ray are cousin brothers. The court recorded that it stood clearly admitted that Hakim Ray was the uncle of Dwarka Ray, and Dwarka Ray was the nephew of Hakim Ray, and his Uma Ray is established to be the son of Gauri Ray and not the brother of Gauri. And the issue was accordingly decided. The issues were accordingly decided against the plaintiff and in favor of the defendants. The learned first trial court then thereafter took up issue number 1, 2, 5 and 7 and held that the plaintiff had no valid cause of action. And ultimately the suit was dismissed. So far as the learned first appellate court is concerned, the following points for determination was framed in paragraph 15. The learned first appellate court also considered the materials on record. And recorded a finding that in the present case, the parties of title partition suit number 4 of 1964 were predecessor of both the sides, and the properties were the same as mentioned in the schedule of the plaint in the present case. The earlier title partition suit was brought by Rukmani Devi, who was the sole daughter of the recorded tenant Hari Rai. And also recorded that the genealogy given in title partition suit number 4 of 1964 was never controverted, and according to the genealogy, Gauri Rai was the son of Lakshman Rai, and Gauri Rai had 4 sons, namely Uma Rai, Hakim Rai, Pancham Rai, and Hari Rai. The court ultimately held that the judgment passed by the ruling subject was binding. The findings are recorded as under. यहाँ से quote करेंगे. Page number 69 से. The court ultimately held that it was quite clear that the plaintiff failed to bring any potent evidence from which it could be inferred that Omar Rai was the brother of Gauri Rai, and that the judgment immediately passed in title partition suit number 4 of 1964 was obtained by suppressing material facts. While deciding point number 2, the first appellate court recorded that the parties were in possession of their respective shares as per preliminary decree and final decree of title partition suit number 4 of 1964 for the same properties as involved in the present case, and ultimately held that there was a previous partition with respect to the suit properties. By deciding point number 1 and 4, the learned first appellate court recorded that predecessor in interest of both the parties were parties to the title partition suit number 4 of 1964 for the same matter, and the decree and the judgment to finality. Further, for the same reason, title suit number 15 of 1987 was decided on the preliminary issue of res judicata by order dated 30/4/1991 by the Court of Assistant Settlement Officer. The court was of the view that the principle of constructive res judicata will be applicable in the present case, and the compromise was only for the purposes of exchange of the suit plan between the parties. So it would not be said that the final order to be placed on the basis of compromise. The findings of the learned first appellate court on this point is recorded as under page number 75. This court has gone through both the judgments passed by the learned courts and finds that there are concurrent findings recorded by both the courts with respect to the previous partition, title partition suit number 4 of 1064, and both the parties were in possession of their respective shares arising out of the same partition suit. The counsel for the appellant has referred to Exhibit 1 to submit that it has been recorded the names of children of Uma Rai and Gauri Rai has been recorded therein. However, admittedly, their father's name has not been recorded in the state document, and during the course of argument also, the learned counsel has also stated that the name of their father has not been recorded in Exhibit 1. Otherwise also, this court finds that both the courts have considered every aspect of the respective case of the parties and have felt that there was already a previous petition with respect to the suit property in title suit number 4 of 1964. And subsequently, another title suit number 15 of 1987 was also dismissed by holding that the suit was barred by res judicata. This court finds that there are concurrent findings according to the courts, and accordingly, no substantial question of law arises in this case. This appeal is dismissed. इसको छोड़ देंगे, आप बाद में ले लेंगे।
बात नहीं
आप ले लीजिएगा बाद में। उनको याद करके उनका नंबर ले लीजिए, उनको बुला के लीजिए।
अपीयरेंस दे दीजिएगा और नंबर दे दीजिएगा। Item 35, second page 195 of 2025.
Concurrent finding, Your Lordship, there is some confusion with regard to genealogy. Can I pray next week? With whatever Your Lordship so impose it. Because it was at my instance I was blessing this to you. I can show illegality, but I made.
No. Why do you need time for this? आपको टाइम देने से हमको समझ
नहीं वो genealogy में थोड़ा एक जगह क्लैरिटी नहीं।
तो पढ़िए ना, अभी टाइम पढ़िए। आपको कितना टाइम लगेगा?
ठीक है हम
For hearing item 36, second appeal 142 of 2005.
Who's for the appellant? Yes.
This matter, whether may be referred to mediation, whether settlement
No.
or if not,
आप कैसे? Argue your case. Argue your case.
the case is in short case is that the appellant has booked some materials. So
What is the substantial question of law?
the substantial question of law in this case below. Whether the shortage of goods booked for transportation at the railway at the risk of railway have not been sufficiently denied will be deemed to law to have been admitted by the defendants.
What is whether the substantial question of law? Please.
The substantial question my lord, is the main question in this case my lord. Whether the shortage of goods booked for transportation at risk
कहाँ से पढ़ रहे हैं? कौन सा ऑर्डर पढ़ रहे हैं?
हम ऑर्डर नहीं पढ़ रहे हैं, हम पारा 5 में substantial issue है।
अरे भाई जो फ्रेम हुआ है वो पढ़िएगा कि आप अपने पिटीशन से पढ़िएगा?
Issue है विषय में my lord है।
पढ़िए।
Para 3 at page 19.
Para 3 at page 19.
Page 19.
भाई सब्सटैंशियल क्वेश्चन ऑफ लॉ जो कोर्ट ने फ्रेम किया आप वहां से पढ़ेंगे कि आप कहां से पढ़ेंगे?
वही
कौन से ऑर्डर से सब्सटैंशियल क्वेश्चन ऑफ लॉ फ्रेम हुआ?
सब्सटेंशियल क्वेश्चन ऑफ लॉ जो ऑर्डर में ही है।
इंप्यूट ऑर्डर में सब्सटैंशियल क्वेश्चन ऑफ लॉ मिलेगा आपको।
जो इशू which has been thrown by what that is there.
सब्सटैंशियल क्वेश्चन ऑफ लॉ आपको इंप्यूट ऑर्डर में कहां से मिलेगा?
और नहीं हमारे पास जो
रिकॉर्ड में नहीं है सब्सटैंशियल क्वेश्चन तो यहाँ हम ले सकते हैं।
ये हम 20 सेकंड अपील करूं ये नहीं है।
बहुत अच्छी बात है, नहीं किए तो डिस्कस कर देते इसी ग्राउंड पे, यही बोल के कि आपने कभी सब्सटैंशियल कभी किया नहीं है ऐसे। व्हाट इज दिस?
एडमिट किया हुआ कि वो सुन नहीं पूरा रिकॉर्ड नहीं आ रहा है।
बहुत अच्छी बात है, टाइम तो नहीं देंगे, टाइम मांगिएगा तो 1 लाख रुपए कॉस्ट करेगा। सब्सटैंशियल क्वेश्चन ऑफ लॉ आपको इंप्यूट ऑर्डर में मिलेगा।
That no matter I committed to bid officer.
इससे नंबर 142 ऑफ 2005 आपका वकालतनामा है, किसके इंस्ट्रक्शन पे विड्रॉ कर रहे हैं आप केस? ऐसा खड़ा होकर विड्रॉ कर लीजिएगा केस। यस,
वकालतनामा इसमें वकालतनामा फाइल कर दो।
who are you
I have been instructed.
and you are praying for withdrawal of the case
But I have been instructed, my lord, that they
to
are.
withdraw the case?
Yes, my lord, they are not
Then-
very much interested.
Okay, they are not interested, very good, you have been instructed to withdraw the case. Who has given you the instruction? Who has given you the instruction?
No, sir.
नाम बताइए। तो ये सब लिखना पड़ेगा ना, आपका वकालतनामा नहीं है यहाँ
ये
पर।
तो हमने वकालतनामा दे देंगे।
नहीं ऐसे नहीं, क्या करें? जिस डीएफटी आपका डिस्कस कर सकते हैं, ऐसे ही डिस्कस कर सकते हैं, क्या करें?
Otherwise, also not there.
Should I record? Should I record that you submit that there is no merit in this case?
No, no, I will not submit, my lord. I may permitted to withdraw, my lord.
Under whose instruction?
The instruction has been given by the chief law officer of the company. And since I don't have wakalatnama in this case, I give obviously. My lord is you type on file wakalatnama for
साइन करना होगा। आप विड्रॉल का प्रेयर कर रहे हैं, हमको क्या जाता है, हम आपका विड्रॉल का प्रेयर अलाउ कर देंगे। साइन करना होगा आपको वकालतनामा।
हम साइन कर देंगे। 1980 का जो डिस्प्यूट है 80,000 रुपया के लिए उसमें आज तक लड़ रहे हैं। They are saying that they have lost their interest. Only 80,000 rupees is involved in this matter.
नाम शो करना है। The learned counsel for the appellant seeks permission to withdraw this appeal. On instructions, seeks permission to withdraw this appeal. And he submits that permission be accorded, and accordingly the substantial question of law need not be answered. Considering the submissions, this appeal is dismissed as withdrawn. Thank you. दो substantial question of law बनाना support करेंगे। Mr. Dhananjay
साइन
Patil,
कर
please put your signature. Withdrawal का order ऐसे नहीं होता है, मैं sign
1937 second bill 106 of 2006
withdrawn लिख के sign करना है। Yes, appellant. $77 का टाइटल सूट है। Where is the appellant? the second appeal number 106 of 2006. Nobody appears on behalf of the appellant. The appeal was admitted on 6/12/2017 by framing following substantial question of law. The matter arises out of eviction case number 4 of 2006, whereby the appellant has been directed to be evicted on account of default in payment of rent and the prayer was also made for realization of arrears of rent. The suit was reviewed and the appeal was allowed. The suit was dismissed and the appeal was allowed and consequently an order of eviction was passed. Today when the case is taken up, nobody is appearing on behalf of the appellant and no advance notice seeking adjournment has been circulated. On 18/8/2022, the case was adjourned. On earlier occasion, the case was adjourned upon payment of cost of ₹1,000. And thereafter again, the case was adjourned at the instance of the appellant. On 16/6/22, the case was adjourned by way of last chance. Thereafter, on 18/8/22, the case was adjourned upon payment of cost of ₹1,000. Thereafter, again, the case was adjourned at the instance of the appellant. Since nobody is appearing on behalf of the appellant, today this case is dismissed for non-proceeding. Communicate the police. Stay updated.
Item 38, second bill 187 of 2008.
टाइम में नहीं मिलेगा वैसे substantial question of law please बताइए ये तो settled है law so just say that
छुट्टी पास किया
कौन सा छुट्टी
विंटर विंटर वैकेशन
कौन सा छुट्टी
इस
2028
2000
पूरा 10 साल हो जाना चाहिए नहीं नहीं टाइम नहीं देंगे आप फाइल खोलिए और बहस करिए फाइल नहीं है 1 लाख रुपए कॉस्ट का डील हो सकती है
बोले हैं
दीजिए को एनसीआर टीम को अपीलेट कोर्ट का रिकॉर्ड दीजिए
इसको
नहीं आपको पता है आपको कहाँ से फाइल पढ़ना है आपको मालूम है पढ़िए
इसमें हम तैयारी नहीं हो पार्टीशन सूट का है
कोई बात नहीं सब्सटेंशियल क्वेश्चन ऑफ लॉ पढ़ाइए रीड द सब्सटेंशियल क्वेश्चन अच्छा हम पढ़ लेते हैं आप तो पढ़े नहीं हैं हम पढ़े हैं ना फाइल तो आया है बताइए क्या है सब्सटेंशियल क्वेश्चन
नहीं पढ़ पाए
हम पढ़ के सुना whether or not the appellate court in view of admission of D.W. Cholara Mehto about death of Radha Mehto in the year 1956 can dismiss the partition suit overlooking the well-settled principle of law that before the year 1937 or before the year 1956, daughter and widow were not entitled to the properties of their father or husband.
इसमें जो इन्वॉल्व है कि एक ट्रांजैक्शन हो गया है राउटर के थ्रू से तो वो उसी दैट इशू इज इन्वॉल्व सो उसको थोड़ा पढ़ना पड़ेगा
पर ये देखिए आपके सामने बगल में बैठे अभी जजमेंट बताएं
नहीं फिर भी हम
बताइए इनको जजमेंट बताइए भाई अगर पार्टीशन नहीं हुआ है लड़की का जन्म कभी भी हुआ हो
नहीं हुआ तो
She's entitled for partition.
फिर भी हमको इस केस में
है ना यही है ना लॉ
एप्लीकेबल होगा कि
You
नहीं
see,
होगा
if a daughter dies prior to if the father dies
इस-
prior to 1937 also,
नहीं
and
इसमें
there has been no partition.
इसमें ये इन्वॉल्व है कि if a person if a male member died intestate prior to 1956 whether daughter would inherit has right of
He
inheritance
should decide what to
वो
consider.
पार्टीशन का बात था
Whether daughter will inherit or not.
उसमें जो पार्टीशन का है वो जजमेंट का हमने दूसरे केस में हम उसको पढ़े हैं कि अगर it is immaterial that where the daughter is born prior to amendment वो हिंदू सक्सेशन अमेंडमेंट एक्ट 2005 का में बिल किया गया लेकिन ये दूसरा इशू है
चलिए ना क्वेश्चन पढ़िए ना फाइल खोलिए ऐसे नहीं होगा क्वेश्चन ऑफ लॉ आपको पता चल गया पढ़िए
इसको थोड़ा टाइम
नहीं पढ़िए
कोई भी
appellate court का जजमेंट खोलिए ओपन इट इतना हम लोग लगे हुए हैं कि मरने के पहले केस डिसाइड हो जाए appellate court का जजमेंट खोलिए
कोई भी छोटी से पहले भी अगर कोई डेट दे दिया
नहीं आप फाइल खोलिए appellate court का जजमेंट खोलिए पैरा 1 से पढ़िए ये सब भी
This appeal at the instance of the appellant plaintiff is directed against the impugned judgment dated 20/2004 and decree dated 5/3/2004 passed by the success from 5 February in partition suit number 2994 by and wherein the learned court below has placed to decree the suit in part in favor of the plaintiff appellant. The case of the plaintiff before the court below was that the plaintiff and the defendants are Hindu and Amrit Mato are the common ancestor of all five parties. Amrit Mato died leaving behind his two sons named Rushdi Mato and Dayal Mato. The Mato died before last survey operation, and so his landed property was recorded in the name of his son Radha Mato. It is the specific case of the plaintiff that the land of Khata number 15 of village Gotu was recorded in the name of Kailu Mato. Land of Khata number 57 was recorded in the name of Radha Mato, and land of Khata number 56 was recorded in the land name of both Radha Mato and Kailu Mato. Radha Mato died in the year 1936 in jointness, leaving behind his widow Sogi Devi and two minor daughters, namely Vilaso and Boni. It is said that at the time of death of Radha Mato, his wife Sogi was a young lady, and with the consent of her mother-in-law, Bhutani, she solemnized her second marriage with her Devar Kasi Mato, and after the marriage, Kasi Mato became the sole owner of the lands of Khata number 15, 56 and 57, and he came in possession thereof. He started paying rent for the lands of all the three Khata number 50, 15, 56 and 57 since the year 1938 to the estate act, and after vesting to the estate Bihar, and Jamabandi was obtained in his name in the Sirista of the Anchal Adhikari Board. It is further case of the plaintiff that after marriage with Kasi Mato, said Sobi Devi gave birth to his son Soda Mato and daughter Gaura. In this way, said Sobi Devi and two daughters Vilaso and Boni from her first husband Radha Mato and his son Soda Mato, and a daughter Gaura from her second husband Kasi Mato. It is also a case of the plaintiff that the said Sobi Devi was his second wife and Patra Devi was his first wife, and Kasi Mato had three sons, namely Gora Mato, Kushan Mato and Vedu Mato, and three daughters Chumni Devi, Deva Devi and Bhumi Devi from his first wife Patra Devi.
So her second husband was also having a second wife.
हाँ वो मरने के बाद दूसरा शादी कर लिया, उसके बाद वो बेटी उसके साथ रहने लगी.
That's I don't know.
The further case of the plaintiff is that Sobi Devi, second wife of Kasi Mato, died in the year 1950, and Kasi himself died in the year 1966. After death of Kasi Mato, his first wife Pato Devi and her sons and daughters remained in joint possession of the son and two daughters of Kasi Mato from his second wife Sobi Devi, the lands of Patananda, Panna, Sarpan and Sardavan. But cultivation work, all lands were done according to the convenience of the sons of Kasi Mato from his two wives, and lands were never partitioned in meets and pounds, and they were paying the rent to the estate of Bihar Mantik. It is said that Kasi Mato himself and his four sons Sodara Mato, Sobi Devi and Bhola Mato, Kushan Mato and Ledu Mato from Patu Devi, who had purchased some lands which have been shown in Schedule B of the rent, and the lands of Khata number 15, 56 and 57 have been shown in Schedule A of the land. In this way, all the four sons are in joint possession of Schedule A and Schedule B lands. It is further case of the plaintiff that in the year 1955, after vesting of Zamindari, the landlord of village Gopu shown the name of Kasi Mato in the return as tenant of Khata number 15, 56 and 57 of village Gopu. It has further been stated that Soda Mato playing role of deed executed by both daughters of Radha, namely Vilaso and Boni Devi, on 11/4/1970 with regard to the lands of Khata number 57 of village Gopu. So both daughters of Radha Mato had no right to execute the same deed since Radha Mato died in jointness of Kashi Mato, and so the same deed executed by Vilaso Devi and Boni Devi cannot create any title. The plaintiff for the time on peace, January 1994, came to know about the alleged same deed. The defendant number 1 filed a petition under section 144 CRPC, and so the relation between the parties became tense, and it becomes very difficult to the cultivation of the deed. The plaintiff approached the defendants for partition of the lands of Schedule A and B, but the defendant refused, and on 12/1/1993, 22/1/1993, the defendant finally refused. The parties partition and hence this suit has been filed. The plaintiffs have claimed 6 by 8 are shared in the suit land and have stated that the defendants have 2 by 9 share only. The plaintiff have sought relief for declaration for the cancellation of safety dated 11/4/1997 executed in favor of the defendant number 1. The cause of action arose on 15/2/1994 when the defendants finally refused to partition the land and on 30 January 1994 when the plaintiff came to know about the execution of the LSLD. The suit has been valued at ₹1 lakh and fixed court fee for partition of the period and employment court fee for cancellation of safety will be filed. In this way, the plaintiff have paid for a decree of 6 by 8 shares by passed in favor of the plaintiff and a separate thirty carved out by the appointment of survey nominated commissioner. It has further been paid that the sale deed dated 11/4/1970 executed by Vilasu Devi and Boni Devi be declared policy invalid, void and the post office should be awarded to the community. On the other hand, the case of the defendant in belief is that the suit is not maintainable in its present form. It is barred by law of limitation and first possession is total limitation. It is also barred by non-joinder of necessary party and both the daughters of Radha Mathur, namely Vilasu Devi and Boni Devi, have not been made parties in this suit. There is no unity of title and possession between the parties. It has further been stated that Devi was widow of Radha Mathur, and it is also false to say that Radha Mathur died in the year 1936. In fact, Radha died in the year 1945, leaving behind his widow Sohi Devi and 2 daughters. Leaving behind his widow Sohi Devi and 2 daughters. At the time of death of Radha Mathur, Dukni was not alive. Marriage of Sohi with Kasi Mathur is admitted, but it is false to say that Sohi married with Kasi with the consent of her mother-in-law Dukni, as he was not alive at that time. It is also false to say that Kasi Mathur remained in the exclusive possession of the land of Kaka number 57 and half of the land of Kaka number 56. It is the other case of it is
Okay,
further
issues study. Page 7.
on the basis of pleadings of the parties following issues have been framed. Is the suit maintainable in present form? Have the plaintiffs valid cause of action for the suit? Is the suit barred by law of limitation and adverse possession? Is the suit barred by historical inacquiescence? Is the suit barred by disjoinder of parties? Is the court fee paid sufficient? Is the sale deed dated 11/4/1970 executed by Vilasu Devi and Boni Devi void, illegal and inoperative? And has the defendant number 1 got any title or possession over the land? Have the both parties joint possession and title over the suit land? Are the plaintiffs entitled to preliminary decree for partition? Are the plaintiffs entitled for relief of reliefs? So main issue is issue number 7.
Issue number 7. Come to page number 13. Both the parties have relied upon the principles.
Both parties have relied upon the principle of law regarding partition of joint Hindu family property. Position of law is admitted. There is no dispute. It is well settled that separate or self-acquired property of a member of joint Hindu family may be impressed with the character of joint family property. If it is voluntarily thrown by the owner into the common stock with the intention of abandoning his separate claim therein, but but to establish such abandonment, a clear intention to live separate life must be established. From the mere fact that other members of the family are allowed to use the property jointly with himself, or that the income of the separate property was utilized out of generosity or to support persons whom the holder was not bound to support, or from the failure to maintain separate accounts, abandonment cannot be inferred. For an act of generosity or kindness will not ordinarily be regarded as a admission of the legal obligation. I do agree that honest lies upon who assures the partition has taken place. In the present case, there is no any legal evidence laid on behalf of the party to come on a conclusion that actually any partition took place or partition had taken place or not during the lifetime of Radha Mato and Kailu Mato. There is no direct denial of the fact that Amrit Mato was a human ancestor of the party. Therefore, this fact appears to be admitted. It is also an admitted fact that the lands of Khata number 57 were recorded in the name of Radha Mato, lands of Khata number 15 were recorded in the name of Kaila Mato, and lands of Khata number 57 6 were recorded in the joint name of Radha Mato and Kaila Mato. The court has to infer the actual position from the entry in the Gyan and subsequent conduct of the parties where there is no evidence laid by the parties regarding partition or not. Partition of the joint family property, therefore, there will be a presumption of jointness of Hindu joint family property until and unless it is rebutted by cogent evidence that partition had taken place. Once a strong circumstances in this case is that there was partition between the family prior to survey and settlement operation in 1912. That it is why the land of Khata number 57 were recorded in the name of Radha Mato and lands of Khata number 15 were recorded in the name of Kailu Mato. Another circumstance is in favor of the applicant that the land of Khata number 56 were recorded in the joint name of Radha Mato and Kailu Mato. DT.10 is the plaintiff Bhola Mato. He has reported in para 7 of his evidence that his house and the house of Solara Mato are separate. He has got 4 plows and Cholam Ram has only 1 plow to cultivate their lands. He further reports that Radha Mato and Kaila Mato had partitioned the lands. His version supports the case of the defendant that there was partition of property before the survey and settlement operation and lands of Radha number 57 were recorded in the name of Radha Mato and lands of Radha number 15 were recorded in the name of Kailu Mato. There might be some reason that the lands of Khata number 56 were not partitioned and that is why it was in the name of Radha Mato. But by admission of the plaintiff himself, it is well established or proved that the Radha Mato and Kailu Mato were not joined with others. They had partitioned the lands prior to survey and settlement operation. The London Court below has rightly held that the lands of Khata number 57 were absolute property of Radha Mato and half of the lands of Khata number 56 was the property of Radha Mato. The second most important aspect in the case has to be decided as to whether Bhavani Devi and Vilasu Devi has got right to sell the lands or whether they inherited the property of Radha Mato. The London Council for the Appearance has tried to impress upon the that prior to 1937, the widows of the daughters of the Hindu men and died without any testament has no right, but the London Council for the respondent number 1 respond may the Mullah's Hindu law in which there is a Vidaksha law of inheritance on such which I have also dealt earlier, and the London Court below has dealt in detail in his judgment, which is very much clear that the property of Radha Mato was inherited by them as they were heirs of Radha Mato, and in absence of any male members in his family, they succeeded it, and after enforcement of Hindu succession in 1926, they become absolute owners of property. The contention of appellants
The daughters had sold the properties.
and daughters have sold, but admittedly in the pleading itself it has come that they have died in the year 1945. So the daughters whose father had died in the year before 1956, they have had no right to transfer.
They had transferred in 1970.
They have transferred in 1970. But the point is, the
They acquired the status of co-partner.
they could not acquire the status of co-partner as because inheritance doesn't come in view of the fact that their fathers died in 1950 before 1956. So before commencement of the new succession act, that is why they are not the doubters had no entitled to get to transfer that land of their father. यही क्वेश्चन इन्वॉल्व है.
जजमेंट लेके आइए.
हाँ,
कब लेके आइए?
इसको छुट्टी के बाद ही
छुट्टी के बाद ही रखना. कल ला सकते हैं.
नहीं, कल जल्दी होगा.
फ्राइडे को लेके. फ्राइडे को लेके आइए. फ्राइडे सुनेंगे. उसके बाद होगा तो सैटरडे सुनेंगे. सैटरडे
इसको थोड़ा बहुत कॉम्प्लिकेटेड मैटर है, इसलिए प्रॉब्लम है कि जनवरी में रखते हैं.
कोई बात नहीं. आप जजमेंट लेके. इसीलिए आपको फ्राइडे को सुनेंगे. ज़्यादा कॉम्प्लिकेशन लगेगा तो मंडे को फिर सुनेंगे. लेकिन अब इतना पुराना केस नहीं है जनवरी में, है ना? रिस्पोंडेंट कहाँ है? रिस्पोंडेंट एब्सेंट है.
नोटिस तो सफा गया.
रिस्पोंडेंट को कोई मतलब नहीं है. सेकेंड अपील पे एब्सेंस है डिसाइड. नहीं आएंगे तो कोई बात नहीं. वी डोंट बॉदर अबाउट देम. ऐसा थोड़ी है कि आप हार ही जाइए. आप जीत भी सकते हैं.
नहीं, वो तो हमको होता है कि हम जीत जाएंगे.
हाँ, तो आपको होप है ना. तो रिस्पोंडेंट नहीं है तो इसमें
बट
चिंता करने का बात
कोई बात नहीं पढ़े रहने से समझाने में दिक्कत.
आप पढ़ लीजिए. 2 दिन बहुत है आपके पढ़ने के बाद. फ्राइडे को रखिए. देखिए सेकेंड अपील नंबर 187 of 2008. Substantial question of law has been framed by order dated 19th of February 2020 as follows. The hearing of this case has commenced. However, the counsel for the appellant seeks adjournment. Nobody is appearing on behalf of the respondents. Pose this case for further hearing on Friday. फ्राइडे को तो रेगुलर पेशेंट का 7:30 एक्टिविटी. फ्राइडे को कोई सेकंड हाफ का केस फिक्स नहीं लगता. 2:30 फ्राइडे. ठीक है, तैयार होइए. अच्छा केस है. बहस करिए. कहाँ है मिस्टर राहुल गुप्ता? क्या हुआ? कमिंग. हैज टू कम.
For judgment item 11, second appeal 190 of 2022.
This appeal is dismissed.
Orders with
अगर
effect.
कोई मैटर है
टारगेट केस में ऑर्डर में 3 और 4 है. नोटिस 3 में भी हुआ था, 4 में भी.
टारगेट केस टिकट नहीं हुआ ना.
नहीं टिकट. उसमें एक चीज है, जो 3 में जो है सो नोटिस चला गया, उसका रिपोर्ट आ गया इसकी रिसीट. 4 में जो है बाय मिस्टेक वो लोग लेट से नोटिस फाइल किया, इसलिए नोटिस इशू नहीं हुआ. यही ऑफिस नोटिस को कंसीडर इशू हो जाएगा तो नेक्स्ट डेट तक ये.
4 वाला.
हाँ 4 में
3 and 4 both
साथ में ही है. Wani Kumari has filed the notice, but it was filed a bit late. Therefore, report is that it was
प्रेम की ऑर्डर नहीं था.
negative. कुछ नोटिस में भी डिफेक्ट था जिसके लिए 3 में नोटिस ये रिपोर्ट आ गया.
है नहीं. अब कुछ नहीं कर सकते.
इसको खाली ऑफिस को
एब्सेंस में कैसे हम
ऑफिस खाली इशू करेगा. नोटिस ऑलरेडी फाइल्ड है, तो एक ऑफिस नोटिस फाइल्ड है. नोटिस का कॉपी पूरा फाइल है, खाली इशू नहीं हुआ है.
हमारे ऑफिस में अपना ऐसा नहीं है.
हाँ है, शुरू में ही है. notice has been filed, but it has been filed late, therefore it has not been issued.
essay number 108 of 2005. As per office note, on 5/12/2025, requisites for service of notice upon the proposed legal affairs of respondent number 1 has been filed. But the same was filed belatedly,
Deleted. Therefore it was not issued.
and therefore the notice has not been issued. Office is directed to issue the notices for which requisites have been filed. Fixing the next date of hearing. ये इशू करा देंगे, इसके बाद पोस्ट ऑन कौन सा डेट के लिए पोस्ट करें?
जनवरी में ही होगा। तो फर्स्ट केस में खाली नोटिस वैलिडली सर्व आ गया है, रिपोर्ट आ गया है, ठीक है। वकालतनामा has not been filed, but notice has been served as per report.
3 करना का तो ये ऑर्डर शीट सब मतलब ऑफिस नोट सब।
Yes.
बस अब मेरे रिटायर होने के बाद ही ये केस डिसाइड होगा।
नहीं,
ऐसा हमको लग रहा है।
उनका केस तो कंकरेंट फाइंडिंग है, मेरा रिवर्सल है, इसलिए हम चाह रहे हैं।
कौन सा नेक्स्ट डेट है इस केस में?
अभी डेट नहीं है,
कोई डेट नहीं है।
नहीं, आज ही फिक्स करें।
कौन सा 9 को?
Order petition action for file number 1st April 8903 of 2024.
हाँ बताइए।
वैल्यू नहीं उसने भी ये बात नहीं दी बात भी आ गया बात उसने भी बताया
फाइल नंबर 8903 of 2024. The sole surviving defect is that suit primary is missing the certified copy of the DT and as DT LA number 1 of 2007. The DT was sent for correction.
ना इसमें डिक्री में भी सूट वैल्यू नहीं है जो
करेक्शन के लिए भेजा गया था ना?
हाँ करेक्शन के लिए भेजा गया था लेकिन उसमें
The decree was sent for correction, but it has been reported that suit value has not been mentioned anywhere. Nor any court fees was filed by the petitioner of the case. Land reference case. LA case दिखाना है।
हाँ पहले दुकान तो खुद से
In view of the report received from the concerned court, the defect in connection with suit valuation is ignored for the present. अवार्ड कितना का बना है?
You are dismissed. Award नहीं होना।
ओरिजिनल अवार्ड कितने का बना है? Because we are fighting for the amount, no? Apportionment का केस है. What was the original award?
Original award इसमें कोई कहीं मेंशन नहीं हुआ है। इसमें नोटिस भी हुआ था हमको नहीं हुआ था। नोटिस को हम चैलेंज किए थे।
This defect is ignored for the present, subject to any objection that may be raised by the respondents. ठीक है? और तो कोई डिफेक्ट नहीं है?
ना
इसको ऐसे फाइलिंग नंबर में एडिट कर हो जाएगा नंबर ऐसा oppose this case on Friday in the supplement on the application. Case number पड़ेगा तब नोटिस कराना ये तो confusion होता है
Item 13, second appeal file number 1836 of 2025.
I have been filed for ignoring the defect number 25, Lordship.
regarding
Lordship, the office has pointed out that appellate number 4, namely Mohar Devi, has not been made party in the present appeal, Lordship. The Mohar Devi died after passing of judgment and decree, Lordship. And
the
her
death certificate
death certificate not mentioned, Lordship. And death certificate दिया हुआ है, initial number. जी. Death certificate दिया हुआ है.
और इंक्लूड जजमेंट कब का है
आपको
25/11 she died on 5/11
and her legal years are already on record as a appellate number 2 in the Lordship.
essay number 1836 of 2025 the learned counsel for the appellant has submitted that IE number 16174 of 25 has been filed for ignoring the defect number 25 wherein it has been pointed out that appellant number 4 of the decree under appeal has not been made party in the conversation. He submits that appellant number 4 namely Mahadevi
उसमें मोहर देवी
Mohar Devi
जी
appellant number 4 in the decree under appeal namely Mohar Devi has expired on 5/12/2024 after the passing of the improved judgment and therefore she has not been made party in the present proceedings. He submits that her legal years are already on record as appellant number 2 and 3 and therefore the defect will be ignored. Considering the aforesaid submissions, he has also submitted that the death certificate has been based on record. Considering the aforesaid submissions, defect number 25 as pointed out by the office is ignored for the present. आगे बताइए
आगे जो नया साल में बहुत फिक्स हो चुके हैं हम लोग ना नया साल में जब भी कर लीजिए
कर कहाँ पा रहे हैं
नया साल
Office is directed to place this case and the appropriate hearing on 12th of January.
First appeal file number 5636 of 2025.
Yes.
My
not in this case, appellant had went to the Supreme Court against the order dated 4/11/25.
Means what happened?
इसमें disposal नहीं हुआ, इस डायरी में
Yes, they-
इसमें
Diary number is there, Your Lordship. The case is still pending in the Honorable Supreme Court.
disposal के बाद कोर्ट पॉइंट पर वो डिसमिस हो जाता है, आयु फाइल किए थे रिव्यू कर देते हैं, डिसमिस हो जाता है, ऑर्डर डिसमिस हो जाता है सुप्रीम
Filing number FA 5360 of 25. The learned counsel for the applicant has submitted that the facility filed against the order dated 4th of September 2025 is pending before the Honorable Supreme Court. Closed this case on 9th of March, office to report on the present status of the case.
Appearance. Appearance. Order citing 15 second appeal 107 of 2009.
What is this?
Subsequent petition filed in notice was issued received by
Who's substituting? Who has died when?
it's number 6 and 8.
6 and 8. What is the reason for delay? When did 6 die? When did 6 die? Yes?
24/2/23
24 to 20. At 8. 8 का कब देते हैं?
16/8/24
Notice has been served. SN number 107 of 2009. Date. IE number
4287
IE number 4287 of 2025. This petition has been filed for substitution of respondent 6 and 8, who are said to have expired on 24/2/23 and 16/8/2024 respectively. A prayer has also been made for setting aside abatement and for condemnation of delay in filing the substitution, which is 641 days for respondent number 6 and 125 days for respondent number 8. The learned counsel for the applicant has submitted that they had no knowledge about the death of the respondent 6 and 8. Notices were issued and they came to know only when they inspected the records. The matter has remained pending before this court since 2009. Notices were issued upon responding numbers upon the proposed legal years and successors of respond number 6 and respond number 8. And notice, and as per office note, the notice has been served either personally or through their close relative. The legal counsel submits that the notice be accepted as validly served and the substitution be enacted. Considering the opposite submission, the notice upon the proposed legal units and successes on respond number 6 and 8 is accepted as valid. Peruse the amendments in I number 4287 of 2025. And considering the statements made in the integrity application, the prayer for substitution is allowed. The delay in filing the substitution petition is allowed. The IA itself is allowed. The counsel for the appellant is directed to delete the name of respondent number 6 and 8 from the cost typing and insert the name of the lawyers and successors in writing during the course of the hearing. कब का चल रहा 2009? Substantial question of law क्या है?
Learned lower appellate court without meeting the reasoning, the learned trial court reverse the judgment.
Since the second appeal is of the year 107, अब तो और तो कुछ नहीं बचा है इसमें.
नहीं.
The learned counsel for the appellant करेंगे कब करेंगे?
जनवरी में मुझे रख दिया जाए.
The learned counsel for the appellant submits that the matter be posted for final disposal in the month of January 2026. Post for final disposal on 28th of January, this January 9/26.
Item 16, second appeal 508 of 2016.
For what?
Respondent.
For what? To the respondents. There is a substantial question.
I number 12719.
Respondent number 7 to 9 ने वो इसमें काउंटर एफिडेविट फाइल किया. Who is there? किसको नोटिस हुआ था? बताइए.
5 and 6 के
आइए नंबर कौन सा है?
10719.
3, 5 and 6.
3 was appellant.
अच्छा अपीलान नंबर 3, respond number 5 and 6. अपीलान नंबर 3 का वकालतनामा 5 कर दिए हैं. लीगल यूज कर दिए हैं. और 5 and 6 को नोटिस हुआ था.
On behalf of 6.
लीगल यूज ऑफ respond number 6.
6 second on behalf of 3 sons of respondent.
You have filed वकालतनामा. Do you have any objection for substitution? Respond number 5 is anybody clearing? 31238 आपने सबकी तरफ से फाइल किया है.
So appellant.
अभी ये आपकी नाम और 8 and 9. Respondent number अपील नंबर 5 की तरफ से कौन? कोई फाइल की? Respond number 5.
515 को delivered everything
आप कब फाइल किए? कब?
Filing today.
Filing today? Or you have filed it?
I filed it. I filed it by today itself.
SA number 508 of 2016. Notices that issued to the proposed legal years and successors of respondent number 5 and respondent number 6. The notice upon respondent number 6 within bracket Roman 6 has returned unserved by observing that receiver was not found. Also, for the applicant is directed to take steps for direct service of notice upon respondent number 6 within bracket Roman 6 through the concerned police station. पुलिस स्टेशन जब से जाएगा तभी नोटिस सर्व होगा. ठीक है, पीएम को तो लौटा दिया, अब का पता नहीं. Refuses be filed by 22nd. सिर्फ एक के ऊपर रिस्पॉन्ड नंबर 6. 6 का रोमन 6 यहाँ फाइल करते हैं. The service report of respondent number 7 reveals that notice's father name does not match, and therefore the notice has been returned unserved. Counsel for the applicant is directed to seek instructions. बाप का नाम नहीं जारी करता. Postman welcome Janvi.
एक urgent matter was there in interim order till today was item number 27 and notice I had released the record according to office reports.
सुबह से क्या करते हैं?
गलती हो गया, हम मेंशन नहीं कर पाए. आज ही भरे एक बार ऑर्डर शीट लॉट शीट देख लिया 27 का एक डेट का फिक्स कर दिया है किसी भी दिन लॉट 27 आज ही भरे.
जब पार्टी एप्लीकेट कर जाता है यहाँ पे
नहीं अभी हम नहीं किए हैं, अभी हम नहीं किए हैं.
देखा है चला रिकॉर्ड
27 अभी हम नहीं किए.
My lord, in this matter today I received the Vakanatnama on behalf of the respondent.
All the respondents.
1 to 7. 1 to 7 matter.
So you want continuation of stay or you want to undo this?
Ma'am, can you give me a date?
When do you want?
Ma'am, any date?
Any date अच्छा इनिशिएट यहाँ पे मत बोलिए, इनिशिएट में बहुत खतरा है आपको। बताइए आपको कब किया, आपके सीनियर कौन है?
मैडम इसमें विशाल त्रिवेदी मुसीबत की है, वो उसमें एडमिट करेंगे मैम।
तो कब डेट रखना है बताइए, क्योंकि स्टे हम एक्सटेंड करेंगे।
नो
मैम
डे आफ्टर टुमारो।
ऐसे नहीं, आप उस दिन आके आपके सीनियर टाइम मांगेंगे, बोलेंगे
नहीं,
हम आज एंगेज किए हैं, ऐसे नहीं होता।
21 if possible.
ठीक।
ऐसे नंबर 116 of 2025। MS नाम बताइए, नाम पूरा नाम बताइए, अपना नाम
एडवोकेट रेणुका त्रिवेदी।
Advocate Renuka Tiwari appears and submits that she has received Wakalatnama on behalf of all the respondents and undertake to file the same by day after tomorrow. By day after tomorrow. He submits that the matter can be heard finally on 21st. 21st December Sunday, madam.
My phone. Friday.
छुट्टी के बाद वार्षिक 6 तारीख को रख दिया जाएगा।
हाँ मैम।
6 तारीख को रख दिया किसी ने कंटिन्यू
स्टे तो कंटिन्यू होगा। आप जहाँ टाइम मांगिएगा स्टे करेंगे।
नहीं 6 तारीख को रख कर
बताइए
6 तक यहाँ स्टे
क्या होगा?
उतना ही दिन तक रहता है।
उतना ही दिन तक रहेगा। 6 तारीख को रख दिया।
ठीक है।
She submits that the matter may be posted immediately after vacation, and she is ready for getting the matter finally argued on 6th. Right?
Till then.
The consent of the parties post this case on 6th of January 2026. For final disposal, 25 का केस है अब वही।
हाँ फाइनल डिस्पोजल में रखते हैं। फाइनल ऊपर में रहेगा डिस्पोजल।
इसका हम नहीं गारंटी दे सकते। Till 6th. Further proceeding in execution case number 11 of 2017 shall be reinstated. That is already communicated. हो सके ना कि कल कर दीजिए। क्यों?
ठीक है ठीक।